Welcome back to the Oxendine Law Podcast. Look, not every divorce has to be a long, expensive, drawn-out battle in court. In fact, mediation is an excellent way to resolve your divorce dispute and reach a fair agreement without having to be dragged through trial. Today, we're going to talk about mediation. We're going to talk about how it works and whether or not it would be the right fit for your case. So, Christine.
Yes.
Basic, easy question. Softball question for you. One I'm sure you can't answer. What's mediation?
So mediation is a process where we sit down and try to reach an agreement. So generally we're in one room, ourselves and our client is in one room or one virtual room. We do a lot of Zoom now. The other party and their attorney are in another room. You never encounter one another. That's a big question I get. You never see one another. The mediator, a neutral person, goes back and forth and helps us work to try to reach an agreement in your case. I've also had clients ask, why do I need to pay a mediator to do that? Because that person, while they are a neutral, they generally are either an attorney or someone who's very knowledgeable about the divorce situations, and they can give both our client and the other side a neutral and different perspective on these potentials for settlement. A lot of times we're paid advocates. That doesn't mean I always agree with my client, but I have heard my client's story, and my client can tell a compelling story. And it sometimes helps me to hear what the other side's going to say from a neutral person, not from their paid advocate who's also sort of overly advocating for that side. I've heard my favorite mediator say that his client is the agreement. So you represent one client, they represent a client, and his client is the agreement. And it is his goal to get us to that agreement.
Yeah, and there's just a lot of benefits of mediation, I think, over trial. Number one, it's much more informal. Your client's not going to have to get on the stand and be put under oath and be asked questions from the court and from the other attorney. It allows you to have control over your outcome, which is what I like the most. Because trust me, folks, when you go try your case in front of a judge, you're not always going to get everything you want. In fact, you may be shocked at what the judge actually does in the case. I can't tell you how many times I walked into court thinking I was just sure of what the judge was going to do, convinced. And sometimes I'm right? But sometimes I'm wrong.
Right.
And the judge does something that nobody even asked for. I didn't ask for it. The other side didn't ask for it.
Like, I feel like I know what they're asking for. I know what I'm asking for. And the judge does a third thing that none of us ever contemplated and probably was the least favorable option, because if you didn't propose it and I didn't propose it, chances are neither one of us wanted it.
That's right. And so now nobody's happy because nobody got what they wanted.
Right.
But at least in mediation, you have control over the outcome. So keep in mind, the only way you reach an agreement at mediation is if you reach an agreement that you're willing to abide by. If you don't reach an agreement because you don't like what's on the table or for whatever reason, you can walk away at any time. But if you reach an agreement, you've got control over that outcome. You know what you're going to get. There's no uncertainties, and you can plan around that as opposed to just throwing up in front of a stranger with a black robe that's going to make decisions about the last 20 years of your life in a period of several hours.
Yeah.
Probably don't want that. Now, there are times where that's necessary, and we're going to talk about that in a second. But another benefit of mediation is it allows you to get more creative with solutions, right? Courts can only do certain things and provide certain remedies. In mediation, you can get really creative.
Yeah, I think that's probably my favorite part of mediation. The most beneficial part of mediation is it is the only time that your case is going to be considered in the uniqueness that is your case. We always talk about judges sort of doing the cookie cutter, the standard, what they normally do. There's only a few options on the table for a judge because he or she simply cannot gather the information that they need to be more specific. So a primary example, if there is a marital residence, the husband says, I should be able to keep it, and a wife says, I should be able to keep it. Chances are the judge is just going to say, okay, we sell it. Because why should he or she have to really think about it and determine who's more deserving of this? I know she says she earns less and she wants to keep this. And then he says his parents, just live around the corner. And they don't want to take all those into consideration. So they just say, easy, we sell it. Where at mediation, we're really going to be able to talk those things out and come up with a better, more creative solution than just, I'm tired of listening, put it on the market.
Yeah, and one last benefit of mediation is cost. Mediation is much more efficient and effective when it comes to cost. It is the amount of time for your attorney to prepare for mediation is probably a fraction. I would say a quarter or less, maybe 10% of the time that it would take them to prepare for trial. Trial is expensive to prepare for. You have to get exhibits ready. You have to prepare opening statements and direct examination questions and cross-examination questions and get your witnesses ready. And sometimes you have to prepare pretrial orders. Just hours and days go into preparing for a trial. And then you actually have to go try the case in front of the judge. You're talking about thousands and thousands and thousands and thousands and thousands of dollars. Mediation is a fraction of that cost. So there's a huge cost savings if you can get your case resolved by compromise in mediation. Now, mediation is not for every case.
Right.
So, and we're not saying it's for every case. We've had plenty of cases where one side is just unreasonable. They don't want to settle. They will not compromise on their position, and their position is insane. Not a good case for mediation.
Right.
That's the case you just have to go try.
Yeah.
Because if they're being that stubborn and that unreasonable and that unrealistic, then chances are you are going to go and kick butt at trial.
But the good news is we rarely see that even on every issue. Now, I've had cases where I think the other party is being, or even my own client, being wholly unreasonable on a single issue. So let's say it's just about the house. I refuse. I'm not going to move. And we're telling that person, you cannot afford to stay in this house under any circumstances. Even if you receive child support and alimony, you still can't afford to be here. And it's just like they won't let go of the position. Then maybe mediation, we just go ahead and go. And we're like, okay, all we're going to address are the other things. So there's the other benefits of mediation are you can do a partial agreement, a temporary agreement, or even just a limited issues mediation where, okay, certain things I'm pretty sure we can get there. And then we'll just know that one thing is all we have to take to the judge and you've limited your trial.
Yeah, that's a possibility. And if somebody's being unreasonable on ancillary issues, then yes, by all means, mediation is a great way to still resolve your dispute. I'm talking about cases where somebody's just adamant that they should have custody and they have never, ever, ever been the primary caretaker.
Right.
They have no flexibility in their work schedule. They just want custody because they don't want to pay child support and they want to basically try and punish and get to the other person. Or even alimony situations, right? You got somebody, it's clearly an alimony case. You got a parent that's been a stay-at-home parent or a stay-at-home housewife or husband, house husband? And you see those now for decades. And the other person's making $1 bajillion and they don't want to pay any alimony, not because they don't think they should have to, just because they want to be a jerk or just difficult, right? And
or
so
the client
those are the
just
cases.
doesn't want to be divorced.
Yes.
You know, that one.
Yes.
The one that's like, nope, I will not agree to anything ever because I don't want this. I don't want this. This wasn't my decision. I don't want anything to do with it. If up to me, we'd still be married. So that client is usually not a good candidate for mediation.
And there's the case you try, which that's okay. We like trying cases, and some cases require that. And the good thing is, don't give in to the bully. So if you've got that person that is just unwilling to compromise, they're unreasonable, it's their way or the highway, the last thing you want to do is go to mediation and give in to their demands. Because guess what? Especially if you still have kids together, they're going to continue to walk all over you until those kids graduate. Stand up to them. Go to trial. Put them into place. Let the judge tell them what they have to pay and when they have to pay it. And that's usually a really good check that hopefully gets their attention and prevents them from trying to control you for the rest of your relationship that you have to have with that person. But mediation is a great tool. And I say, one of the cool things about mediation is, and I'm starting to show my age, doing this now over 20 years, when I first started practicing, mediation was foreign. Like, you would tell a judge that you were going to go to mediation. They're like, huh? You're going to go do what? And they didn't require you to go. They would only approve it if both parties wanted to mediate. Now, most counties, certainly in Metro Atlanta, most judges actually require that everybody go to mediation before they'll even schedule a final trial. So it's certainly very interesting how things have evolved. We also used to do mediation in person, always, without exception. Ever since COVID, everybody started doing remote stuff. And we've actually been doing mediation by Zoom a lot of the time now. I usually will still have my clients come to the office with me just because I think it's more effective if they're there and I can explain things to them and we can actually see and feel each other, so to speak, right? Not like that. But you know what I mean? Having somebody with you looking off the same documents, off the same information where you can answer questions for them in person is a lot different than doing it remotely. But we're still participating in mediation by Zoom on a computer, and the mediator is at their office. And the other attorney and the other client may be at the other attorney's office, or maybe the other party decided to do it from home, but we're all doing the mediation by Zoom. And that's a very comfortable process.
Sure. And I think one of the other benefits of mediation is how that we're able to show our evidence without worrying about the rules of evidence. Jared, how often do we get recordings from our client? And we're like, okay, I don't even know if I could get this in at trial. And I don't have to explain the rules of evidence to you guys, but basically we have to jump through these certain steps. We have to lay the foundation. We have to prove certain things to even have it considered as evidence. And even then the other side can object for many, many reasons. At mediation, we don't have to worry about those hurdles. So I can just play for the mediator. Well, this is the recording that we have. And at trial, I know how to jump through the hoops. I know how to get it in. Yeah, it's going to take a little bit more work and more preparation and subpoenaing additional people to show up, but I'll get it in, and this is what the judge is going to hear. And then sometimes just that alone is enough to say, okay, like maybe we don't want this case going to trial. Sometimes, number one, it lets me know what they're going to bring against me. I get a preview of their evidence, which I highly prefer because that's the best way to prepare for trial in the event we don't settle and have to go. But I also get to sort of strong arm my evidence and say, hey, this is what the judge is going to hear. I don't know that you really want a neutral party hearing you speak about the other parent in this way, or hear you this drunk and belligerent, or hear you in such a violent way slamming stuff. So things like that we can get in, police reports, anything like that that may be a difficult hurdle to jump over at trial. We just get to put it all out there on the table at mediation.
Well, and I'm going to throw this out there. It's kind of off topic, but, as you were talking, it reminded me of the old meet-arb situation, which I love. I've been using that more and more often. Christine, I know you have as well. And what I'm talking about, folks, is a mediation that turns into an arbitration. Now, you usually have to agree on this in advance.
You do.
With the other side and with the mediator. But what you're agreeing to is, okay, we're going to come to mediation and we're going to see if we can settle the case. If we can't settle the case, Mr. or Miss Mediator, you're now becoming a judge. So you're becoming now an arbitrator, and you're acting just like a judge would. And any disputes that we cannot agree on through mediation, you now get to make the final decision as a judge serving as an arbitrator in the mediation. And I love that. Now, why are some reasons you would want to do that? Number one, you got to really trust and like your mediator and make sure that you know their mindset and their legal approach to cases and kind of how they see things, right? Because the last thing you want to do is throw it up in front of a mediator that's going to be an arbitrator that you've never mediated with before. So make sure your attorney knows the mediators, worked with them in the past. But the benefit would be, let's say you are assigned to a judge that's known to be very difficult, or you think that the judge that's assigned to your case is not going to be favorable to your fact pattern in your case, or that county may be backlogged.
Right.
Let's say you want to get this case over with, and the judge is off saying, look, we're sorry, but we are backed up and we can't schedule your final trial for 6 months down the road.
Yep.
All right. You can go ahead and get your mediation/arbitration scheduled and get that done within about 30 days, and you're done. So we actually have started doing that a lot.
Mm-hmm. Yeah, and it is beneficial for all those reasons. And just like you said earlier, the same concept of mediation, you're still having what essentially equates to a trial without having to be in a formal courtroom dressed up with, by the way, open to the public. Literally anyone can walk in and have a seat and just hear what's going on in your daily life. So a much more private, intimate, and casual setting, which is definitely more comfortable. I find that my clients, because the clients do still testify, you're still talking to the arbitrator, but it's much more conversational in tone. I'm not asking a question that you're answering and I ask and you answer. We have a discussion. So that like open flow of information, number one, it's more standard, right? That's how we're normally used to talking. So all the clients are more comfortable just talking to the mediator arbitrator and just telling their story without having to go question, answer. So being able to sort of connect with the arbitrator, let them see your personality and really hear the basis behind why you're requesting the relief you're requesting. It doesn't have to be so clinical and formal. You can really talk about how these certain circumstances have come into play that it may not sway a judge, but an arbitrator is kind of seeing the bigger picture a little bit more, honestly.
Yeah, and lastly, it has a great success rate. I don't know about you, Christine, but the vast majority of the cases that I mediate, I say, and I'm not talking 90%, but more cases than not that I take to mediation actually end up settling.
Oh, yeah.
So,
I've a very, very high rate. At minimum, something has worked out. I can't tell you the last mediation that I left that nothing was worked out. Whether it's even, okay, we're just going to stipulate to the income numbers that we're going to use in a child support worksheet so we can cut that out. I don't know that I've ever left a mediation with literally nothing to gain. And if it did happen, at least I gained a little insight into what they're going to be asking for at trial. So
that's
I've never left mediation empty-handed, and it is extremely rare my client does.
And a lot of people are worried. They're like, oh, mediation is going to be a waste of time. He will never agree to this or she will never agree to that. Mediation has a funny way of getting people in a position where they're ready to compromise. And it's because we have that third party neutral. Remember, the mediator is there to lean on you and lean on the other side to try and get y'all to settle your case. And if you're being unreasonable, that mediator, if you've got a good mediator, is going to tell you you're being unreasonable. Same thing. They're doing the same thing in the other room. Even though you might feel that mediator's only pressuring me, guess what? They're pressuring the other side as well. So that has a funny way of getting people to compromise and get the case resolved. So folks, if you're looking for a less confrontational way to resolve your dispute, give mediation a shot. As always, if you're enjoying these episodes, make sure you subscribe on your favorite platform. If you're watching YouTube, hit that subscribe button, hit that bell. That way you'll be the first to know about future episodes and any updates that we may provide. That's a wrap for today, folks. We'll see you next time.